Good afternoon, everyone. If we can come to order for a moment. I'd like to welcome everyone to the first Georgia Commission on Medical Cannabis. This is a historic day in a lot of ways that we'll talk about in just a minute. But I want to chat for a minute, just make sure everyone understands what we're doing here. We'll introduce everyone in just a minute, the members of the commission, but I do want to just make sure everyone understands this commission has been created by House Bill 1, Haley's Hope Act, and there are specific duties that are charged to this commission. And I'm going to read those for a minute, but let's do a couple of housekeeping. If everyone make sure their phones are turned off, including mine, and make sure we're ready for that. The commission was created through HB 1 and has the following duties, and the commission and members will bear with me for just a minute. I'm going to read them just so we'll all be clear of what our mission is here. Per the law signed by the governor, the commission shall have the following duties: to establish comprehensive recommendations regarding potential regulation of medical cannabis in this state. Such recommendations shall include, without limitations, specification of the department or departments to have responsibility for the oversight of a state-sanctioned system related to medical cannabis. A detailed report, which shall be submitted no later than December 31st, 2015, including a review of the conditions, needs, issues, and problems related to medical cannabis and any recommended action or proposed legislation which the commission deems necessary or appropriate, shall be provided to the Executive Council of the Governor, the Office of Planning and Budget, and the chairpersons of the House Committee on Appropriations, the Senate Appropriations Committee, the House Committee on Judiciary Non-Civil, the Senate Judiciary Non-Civil Committee, the House Committee on Health and Human Services, and the Senate Health and Human Services Committee. And then two, the duty includes to evaluate and consider the best practices, experiences, and results of legislation in other states with regard to medical cannabis. So basically, ladies and gentlemen, the charge to this commission per the instructions of the governor of this state is to come up with, by December of 2015, a recommendation for the governor and the General Assembly of what is the best model for an in-state cultivation, processing, and distribution system of medical cannabis, and then it will be up to the governor and the General Assembly to make a decision at that point of whether to act on the recommendation of this commission or not. So that is the duties of this commission. We are proud to have some of Georgia's smartest citizens on this commission, and I'm going to take a moment to let everyone introduce themselves and let folks know their specialty of why they are here. There are specific appointments on the commission that are permanent positions, and then there are other positions that were appointed by the governor. And so we'll just start down at the end. Dr. Rutterbush, you want to introduce yourself? And
Yes, my name is David Rutterbush. I'm a physician. I practice in Valdosta, Georgia, and I'm also chairman of the Georgia Composite Medical Board.
Okay, thank you, Dr. Rutterbush. Ms. Dempsey?
Representative Katie Dempsey. I represent Rome and Floyd County in the House of Representatives, along with Chairman Peake.
Okay. Senator
Butch Miller from Senate District 49, and I'm from Hall County.
Senator Unterman, Renee Unterman from Gwinnett County, and I'm one of two members of the Senate appointed.
Okay. Dr. Sutton, if you'll tell us who you're filling in for today, too, as well, too.
Okay. James Sutton. I'm Director of Operations for the Department of Agriculture here, and I'm filling in for Commissioner Black.
Okay. Dr. Keenan?
Okay. I'm Vernon Keenan, the Director of the Georgia Bureau of Investigation.
Brian Rickman, District Attorney for the Mountain Judicial Circuit, which is Rabun County, Habersham County, and Stevens.
Stacy Cotton, Covington Police Department, Covington, Georgia.
Gary Gulledge, Paulding County Sheriff.
I'm Cynthia Wetmore. I'm a hematologist-oncologist at Children's Healthcare of Atlanta, and I'm also the Director of Clinical and Translational Research for the Department of Pediatrics at Emory and Children's.
I'm the Young Park from the Augusta, Georgia, GRU, Georgia Regent University. I'm director of pediatric neurology and principal investigator for the governor-sponsored Georgia trial, CBD trial for epilepsy.
I'm Sarah Mandy Reese, Doctor of Pharmacy with Philadelphia College of Osteopathic Medicine, Georgia campus, Swanee, in the School of Pharmacy.
And I'm Brenda Fitzgerald. I am the Commissioner of the Department of Public Health.
Great. Thank you to the members of the Commission. Let me just tell you, first of all, how grateful I am that each of you have been willing to participate in this Commission. It's an important venture for our state. And I know many of you are giving up your valuable time, in some cases, for some of you physicians, money. And so thank you for being here today and participating. Just a couple of ground rules, and we will conduct our business under the Roberts Rules of Orders, which many of you are familiar with. I, as the chair, will kind of direct the discussion, and if you have a question at any time, address the chair for questions. There will be no public testimony today. The only invited guest for this commission here today. This meeting is being live streamed as well. We will probably have another meeting probably in late August or September, let everyone get through the vacation time for the summer, and then we'll probably meet sometime in August or early September. We also will have an official swearing in by Governor Deal. He wanted to be here today to officially swear us all into this commission, but he is in Brazil, so it was going to be difficult for him to take care of that today. So we'll take care of that the next time. Here's our agenda for today. Dr. Brenda Fitzgerald with the Department of Public Health will give some testimony in just a minute of an update of the low THC oil registry, which was breaking news this morning. We look forward to her comments. We're going to get a very quick update from Dr. Young Park of what's going on with the clinical trials at GRU. And then finally, we're going to have the feature presentation with Mike Lizwowski, who's the Director of Government Affairs for the Americans for Safe Access. So are there any questions before we get started of any members of the Commission? If not, Dr. Fitzgerald, would you, if you would mind, go to the front so you can address the Commission. And while she's coming, I'm going to take an opportunity to give a huge shout out to Commissioner Fitzgerald and her entire team. What you're about to hear, I won't steal her thunder too much, but is what they have accomplished in 60 days really is quite remarkable. And so thank you on the behalf of families that you've helped come home immediately, and families that are on their way home, and citizens that will benefit from the legislation passed in HB1. Thank you for a job well done by your agency, and so I'll let you take it from here.
Thank you so very much. My update is to let you know that the registry is now live. As you know, Haley's Hope Act was signed April the 16th. And as of today, June the 16th, we are live. There are several parts of the registry. The intent of the registry is that it should be reasonably simple for physicians, excuse me, and that it should be as safe as we can make it. And certainly we want to guarantee as much as we can that the low THC oil is used for the intention to treat, or those 8 conditions which are described in the law. There are 3 basic parts of the registry that, and I want to tell you about the safety features in each one. The first is the physician component. And if you'll look, if you'll go back just a minute, you can go to our web page, and from that web page, the 3 basic components, patients, physicians, and law enforcement, can find frequently asked questions there. This is also the place where the actual registration occurs. It is most important to note that for someone to be entered into the registry, they are entered in by their physician. The physician will certify that they have one of the 8 conditions that are covered by the law. The most common one we expect to be seizures. And today, sir, we did have some temporary cards, as you know, issued. 20 temporary cards have been issued so far. 18 of those are for children with seizures, and 2 of those are for adults with end-stage cancer. So, when you go to, if you'll look, this is the sign-in for the physicians. The next card, you'll see the next shot you'll see, this is where the physician enters information. They will enter this information once, and then the registry will save this information, so it's from then on they simply have to enter the patient's information. The doctor is responsible for verifying they have one of the symptoms. They'll also give the patient a waiver, letting them sign that's kept in the medical records, so patients know that this is not an FDA-approved drug. And in most cases, of course, this is a substance that is not a first-line drug, but is often a substance that is used when other drugs have failed. So that is part of the law, and that will occur in the physician's office. Then that will be transferred to us electronically. This is part of it was developed in-house. It is part of our notifiable disease registry. It's a component of that. That's a part of our registry that already handles medical information. It is secure. The laws that apply to it are those that protect medical information. And this is a subset of that generalized system that we have. From this point, this will contact the Composite Medical Board, and I want to say, Representative Peak, that they have been wonderful in working with us. This will contact the Composite Medical Board, and it will certify that the physician entering this data is someone that is licensed to practice here in Georgia and is also a physician in good standing. So that's the first component, the sign-up component. It is in a system that is used to handling medical information, and it is a secure system with a guarantee from the Composite Board that we are dealing with a physician in good standing. Then the information will go to our vital records. Vital records is where the cards will actually be printed. I can tell you that the delay of the 2 months is because we got a special printer. We have special cards that have holograms on them. They have the safety features themselves, kind of like a driver's license. So there is a unique serial number and there is a unique card. So the second part is the printing of the card will be done in a very controlled system. It's done in our system that now manages birth certificates and other official records. So it will be printed in that system. The third part, the next part of the safety is these cards will be sent to official registrars. This is a picture of the card. This is the front, and you can see the name and address will be on that card. You can also see the back, if you'll show the back. There's an identification system, and by the way, the law enforcement will have a 24-hour number that they can call, and we will verify that the card they have is indeed in the registry. So, but the handing out of the cards will occur at 18 different locations. These are identified places where there will be a registrar. Again, someone that is used to identifying official records. So when the parent or the guardian or the patient goes to these areas, their identity will again be confirmed, and then the cards will be passed out in person. And again, very controlled kind of situation. And then the last part of the safety is the part I was talking about law enforcement. Law enforcement will be able to reach us 24 hours a day and guarantee that somebody is indeed who they say they are, and that someone is supposed to have a card. We have reached out. We sent out the first cards to the first letter to physicians when the law was signed in April the 16th, and we sent out our second notice to physicians telling them how to access the system. So the letters to physicians have already been sent, and also letters to law enforcement has been sent, and we are in the process of meeting with law enforcement. Our Inspector General is in the process of meeting with law enforcement for a variety of training procedures to occur in the next few months. So that's all been done, and we are live, and I understand that one of the members of our commission accessed our system, if that's right, and he maybe can tell you about that experience. But I will stop now and answer questions.
Thank you, Dr. Fitzgerald. Dr. Retterbush, before you do that, and I do, Dr. Fitzgerald touched on it briefly, I do want to give the Georgia Medical Composite Board a shout out as well too. Your team and LaShawn Hughes, Executive Director, were a key integral part of making this thing happen real quick. So thank you again.
Well,
and why don't you tell us about your?
I had the easy part. They had the hard part.
Yeah, well, they did. You're right. But it started with you guys, and so
anyway,
thank you.
I did register last night. I think it took me about 5 minutes to register, and it was seamless, and everything went fine. So
okay, good. Okay, we'll ask a couple of questions of Dr. Fitzgerald, so we won't get too delayed here. But if there are some questions, there is a button right to the right of your microphone, and if you have a question, if you'll press that, that'll let us know you have a question. I'll ask one real quick, Dr. Fitzgerald. If you could, Sean, go back to the graph that's got the that one, locations. If y'all figured out what kind of drive time that is from what's the farthest someone would have to drive to get to a location?
I believe it was 2 hours, wasn't it?
Yeah, that seems.
I think
Okay.
so.
Okay.
We were going to look. We wanted to start with 18 locations rather than every single registrar, because we wanted to make sure that there was a training process in place. We want to make sure again that next safety component. Certainly, we will be we will be watching for that, and there certainly is a possibility that we will open it up to other registrar areas as we become more familiar with the system.
Okay. Well, I guess the good news is, the furthest someone would have would be 2 hours, but it's for a 2-year card. I guess
Yes.
it's a bit so. They only have to make that trip once every 2 years.
That's
Is that
exactly
correct? Okay. All right. And there's a $25 fee.
Yes, sir.
Is that correct?
That's exactly right. Our usual fee for any kind of official record, birth certificate, that sort of thing is $25, and that's the amount that we put on this.
And you anticipate that from the time a physician inputs electronically the information to DPH to the time that an individual would be able to pick up their card would be?
We are saying 15 business days.
Okay.
I quite frankly think that it will be shorter than that,
Okay.
but we are saying that because we don't want
Sure.
to overpromise.
Sure. Okay. Dr. Wetmore, is that your button? Yep. Okay.
Yes, thank you. I have a question about the reporting responsibilities of the physician. I don't know if this is the time to talk about that, but I think my physician colleagues and some ancillary health providers are most concerned about that.
Yes. The duties of the physician are described in the law. And basically we will do that electronically also. We will have, in public health, all the patients that, for example, are your patients. So we will send you at that quarterly time, these are all the patients that are your patients. And then there are a series of questions that are described in the law that ask, how's the patient doing? Are they still your patient?
Mm-hmm.
Do they still qualify? That sort of thing. And we will try to make those, again, as seamless as possible. Basically a checklist.
And for things like compliance, it's really up to the parental report because it's hard for me to assure compliance. And there's also some concern about releasing patient-related information without a HIPAA release or without an IRB because it's collecting information on patients, which is considered to be somewhat research.
I understand that. We certainly will discuss that with you further, and perhaps
Okay.
that's something that we can do. I can just tell you that it is covered by the same rules that other reportable diseases are covered by. So you are now, for example, as a physician, if you have somebody with meningitis, that information, that patient information is already entered into the system.
Okay.
So this is just a subset of that system that's already covered by those HIPAA guarantees.
That's very helpful. Thank you.
Dr. Wetmore, Dr. Retterbush, you want to answer that? I know the Georgia Medical Composite Board is the one that's actually drafting the reporting documents, and I know you want to just give a quick update on that as well too.
Yes, we have a rough draft of the quarterly reporting form, and I know there's some concerns out there about what's required, but we'll welcome any input to try to refine that. But we will. still working on that, so we hadn't got the final product.
Right. And when they finalize that, then we will put it in electronic form. So again, the interaction with the physician should be relatively seamless.
Yeah, I envision it yes or no, and very little information, shouldn't take long to input.
So not something that will be a burden upon physicians or their staff from a time standpoint.
No.
either.
Certainly not
Okay.
intended.
Right.
And again, we
Okay.
can use the same electronic method to transfer that to you once the agreed upon questions.
Okay. Any other questions? Yeah, Senator Utterman, so you're 22.
On the stars that are on that map, is that the public health department?
Yes, they're public health departments. At this point, we wanted to keep again, because we are responsible for training the registrars how to do it, we wanted to keep it internal. There are other registrars that are not in public health departments, but again, that's why these 18 were chosen for their location.
Where are the registrars that are not in? You said they're not in public health?
Not every single registrar is. Every single county has a registrar. Every single county has a registrar in their county.
Oh, okay.
We chose these 18 because we wanted to concentrate on making sure we got the procedures right. And then once that we make sure our system is working and viable, we certainly can expand out to other registrars. But we started with these 18 because we wanted a controlled approach to this first part.
And without reading back through the law, I don't know word by word, but I don't recollect from a couple of months ago. But is it, I guess, does the diagnosis match up with the physician? Or can it be, like a gastroenterologist would recommend for Crohn's disease? Or can it be a GP can recommend for Crohn's disease? Does it cross any boundaries, or is it subspecialty specific?
The only requirements for the physician are that they be a Georgia licensed physician in good standing.
Okay.
So there are no specific questions in the registry that asks specialty.
So is there a mechanism to flag, like if you had like a hot pocket or you had a physician that was issuing more licenses? Who patrols that, or who looks at that, or who looks for fraud, waste, abuse? Who looks for that?
I certainly think that that's something that we can discuss as a commission. Right now, we are simply the holder of the list.
Mm-hmm.
We can tell you which physicians are doing so. The composite board certainly knows those physicians' specialties, and that has a mechanism to do that other than simple counting has not been devised at this point.
Mm-hmm. So, and I'm not going to belabor the point. I'll go back and read all this. To qualify as a physician, there are certain qualifications, right?
Yes.
So who's monitoring that? The
composite board.
Composite board. So are they required to give a report to the General Assembly? I don't believe they were.
I can't remember either, Senator. I'm not. I've checked. I'm not, and I don't have all of the bill right here in front of me, so I don't sure.
Or does
But that's
law
something we can sure
enforcement
look at.
have- Who has the prerogative to police it, I guess, is in plain terms? Who has that prerogative? Or whose obligation is it? Whose fiduciary responsibility? Or is there one?
I would think the composite
Or is it this board?
Yeah, if there's an issue, if someone makes a complaint or has a concern about a practitioner, we as a board, we investigate every complaint. We get all the information, and if we think there's unprofessional conduct, then we'll take remedy to look into that.
Okay.
That all you got?
Mm-hmm.
I do know, and Dr. Fitzgerald, you can correct me if I'm wrong. I mean, there has to be a bona fide patient-physician relationship for the physician to give. So it may not be the subspecialty that's required, but definitely some type of patient-physician relationship for sure. So, yep, Senator Miller.
On your map there, down in Ware County, you don't have a star, but you have, what do you have going on there?
Yeah, that's the continuation of
Is
the
that-
county. That's the continuation of the county.
Yeah, that is Ware County, but there's
not a Star Wars on.
oh, it doesn't show, okay, it doesn't show it connected.
That's
Okay.
Yes.
Senator Miller, last time I checked, I don't think you represent Ware County, do you?
No, but I like to hunt and fish.
Okay, I do. Okay. Yeah. I'm just looking out for all the citizens of Georgia.
all the citizens of Georgia.
Yeah. Okay. Dr. Wetmore, do you have one more question?
Just a brief comment to Senator Uterman. The fact that some physicians may not feel comfortable attesting, and some physicians may feel more comfortable, so I think that there may be some degree of clustering for those physicians that feel comfortable in working with the patient on this.
Yes, there is no requirement of the physician to certify. That is
Right.
purely the medical decision made by the physician.
And that's a position of Children's Healthcare as well as Emory.
Okay. Dr. Fitzgerald, thank you very much. We appreciate what you've done, and really, we owe you a great deal of gratitude for getting this thing up and running. I chatted with a cohort from another state and told them this was up and running in 60 days, and they were going, gosh, we're 2 years into getting ours up and running, so really
Wow.
great job.
Wow.
So
I'll take that back to my
yeah.
group. Thank you.
We'll let Dr. Fitzgerald come take her spot back here. Dr. Park, are you up for giving us just I know you're welcome to do it just from right here if you're comfortable with that. And I know I'm putting you on the spot, so just a brief update of kind of what's going on with the clinical trial with GWF Pharma at GRU. I know that's you're in charge of that, and so yeah, why don't you fill us in?
Currently, we do have 4 sites. One is Augusta, GRU, and then 2 sites in the Atlanta, 1 site in the Savannah. By the other 3, except Augusta, they are still in processing, finishing all the informations and paperwork. So near soon, Atlanta will running, and then Savannah follows, and then all 4 sites will be ready to recruit all Georgia patients between 1 year to 18 years old who has some kinds of criteria of intractability, means how many seizures per week, how many seizures per month, those kinds of registered inclusion criteria. Once it's fitted, every Georgia state residents will be taking the CBD oil, not the THC component in it, which is clearly provided from the GW Pharma, which is a UK-based of a pharmaceutical company. Currently there is no CBD oil available produced by the U.S. Territory, so only one through the world, GW Pharma, only one pharmaceutical company provide of THC free of CBD oil for epilepsy.
And that product is called Epidiolex, is that correct?
Yeah, Epidiolex is a trade name, and the underneath generic name is a CBD cannabidiol. From January, in the Augusta, where is the on practice, we so far is 20 patients has been enrolled. Among those, you have a certain period of time baseline, and the study on CBD. Now is the less than 10 patients actually receiving CBD oil, which is running right now.
At the Augusta location,
right.
All at the Augusta location. Okay.
Besides of our Georgia trial, there's 2 other studies running, which is sponsored by the GW Pharma, with a particular 2 epileptic syndrome. One is a Dravet syndrome, which is one of the worst case in the children up to 18 years old, which is running, sponsored by the GW Pharma. And there's a Georgia site, there's our Augusta, GRU, and then Atlanta has Dr. Flamini site, has 2 sites is running for recruiting of that particular epileptic syndrome. Second syndrome is also sponsored by the GW Pharma, which is the Lennox-Gastaut syndrome, we call it LGS, which is one of very intractable epileptic syndrome cases run by the GW Pharma. So basically, in Georgia, residents who needs these medications, all epileptic syndrome can be tried. Up to 18 years old, there's no discriminations. Dravet syndrome, Lennox-Gastaut syndrome through the GW Pharma study, and then besides 2 syndrome, all intractable seizure come governor sponsors Georgia trial. So if anyone is a Georgia resident who needs this medicine, there's no way can get this medicine through the study. It does not have to go through the internet or whatever medical marijuana. I'm not recommend those ones because we are CBD oil is available through the study. So that's the current situations. So hopefully this initially up to the 50 patients enrolled, which is sponsored by our state, and hopefully easily can fit up by this year, I believe. That's my expectations. If fit up the 50 patients, we some kinds of agreement between the governor's office and the GRU, we considering to expanding more patients. So it depends on how much is people enroll, how much requirement. That's we expecting to enroll more than 50 patients.
Okay.
So that's the current.
You expect 50 maybe by the end of this year. You expect to be that quick?
Yeah, that's
okay.
I expecting that.
Okay. Okay. And this is just for children at this point. Is that correct?
Up to 18 years old.
Okay. All right. Can you give us any indication? I know you may be precluded because of the clinical trial process of giving an indication of success failure rate with the drug that's being in clinical trial.
In the world, there is no double-blind scientific studies available at this point. Only available data is expanded trial. Expanded trial means compassionate use. So open trial. GW Pharma sponsor the Epidiolex to the physicians who has a register, and then they provide the medicine free charge. That is the so far is 143 patients enrolled until the last spring. Myself has 2 patients enrolled. Flamini has several patients enrolled. Those data is available last December data, and then April this year data that is available. Again, this is not the FDA utilizes this information for approval because of this open label trial.
Right.
So that is currently we have available scientifically is the open label expanded studies about the 150 patients in children.
Okay. Well, I know the state of Georgia and the taxpayers of the state are making a huge investment because we believe in you and what's the work that's being done at GRU, and so thank you for a work that is helping and giving a lot of kids a lot of hope. So thank you for that. Okay, we'll move on to our featured presenter, Mike. And I'm gonna butcher your name all day long, so I'll let you pronounce it. But while you're getting set up there, did Hunter and Aaron just leave? Yes. Okay. All right. I was going to recognize we have a young family. Are they right outside? Yeah. I know he. This whole effort was started because we had medical refugees who had fled our state and moved to another state. One of those young boys is Hunter Kleppinger right here, who I had a chance to meet over a year ago, and his dad Aaron, and so we just wanted that they are now back in Georgia because of the passage of HB1, and so we're glad to have you back. As well as I see Vince Sievert, whose family had moved to Colorado for about 6 to 8 months. And they are all back home as well now too. And Miranda is doing well, and you're registered with the state and legal to have possession of camp soil. So glad to have you back as well too. Okay, Mike, what help me with pronounce your last name so I'm.
Lazuski, Mike Lazuski.
Okay, all right, got it. And Mike's our featured presenter today. And to the members of the commission, I want you to feel free to ask as many questions as you want. Ask hard questions. Mike is the foremost expert in the country on the different medical marijuana laws that are all over this state, all across the map, literally and figuratively. And as well as what's going on at the federal level, and so we're really lucky to have you here today, and grateful to have you here. But I also know we have a very diverse group of mindset on this commission, and so I want to ask you do not hesitate to ask what may be difficult questions of our presenter today, or at any time during this commission. We are charged with coming up with a good solution for our state if it is the public policy of this state to provide medical cannabis to our citizens, and we want to make darn sure we get it right. And so feel free to ask questions. So Mike, you've got a presentation, I believe, slideshow. Will, if members of the commission have a question along the way, feel free to press your button, and we'll, if it's okay with you, Mike.
Yeah, questions along the way
we'll
are
stop
fine, or
and
at
do
the
that,
end,
and we'll try and get through this quick. And if we get done early today, we'll get everybody home before traffic. So, so Mike, it's all yours.
Thank you, Rep. Peak and members of the Georgia Medical Cannabis Commission. I want to congratulate the state for getting the registration card access up and running. That in just a handful of months, that's really quite an accomplishment compared to what a lot of the other states have done. You know, in most states, it takes 18 to 24 months, or in some cases, even 36 months before that even happens. And to hear that there was a 2-month delay, that this could have happened even quicker, just sort of blows my mind. So it really, I think, speaks to just how seriously Georgia is taking this law and this program and this therapeutic access vehicle. And we're really excited that we have this opportunity.
Mike, let me stop you. We should have, the members of the committee have the PowerPoint. Is that correct? I think each of you should have this PowerPoint if you want to follow along as well, too. So.
Okay. And in addition to your PowerPoints, I included our regulators packet. It has information on medical cannabis access in the U.S., which is our state report card report, evaluating all the state programs. Our PFC program guide, which has a lot of recommendations for regulations across the board, from laboratory to cultivation to labeling to processing. It's all in there based on the best practices established by the American Herbal Products Association and the American Herbal Pharmacopoeia Cannabis Monograph, which is a compendium of medical information on medical cannabis. All that is available to you. So. These are materials to review after this hearing, or meeting rather, and hopefully you can digest them. Feel free to contact me after this meeting. I hope this is an ongoing conversation, so I hope that this is just the beginning. Going to give a brief overview of what I'm going to be covering today. I'll tell you who my organization is, Americans for Safe Access. We'll do a brief history, a very, very brief history of cannabis as medicine. This goes back thousands of years, so even if I took the entire 30 minutes, we could only scratch the surface. The current situation, both federally and in other states, I'll give a little bit of a snapshot of what's going on nationally in this field. I'll go over our medical cannabis access in the U.S. report, which, again, that's our state report card report. We have our model legislation in there. And some grading criteria, trying to really get at the definition of what is a medical marijuana state, because we have 23 medical marijuana states, we have 39 laws of some degree of medical marijuana access, and so these laws, some of them are very sparse, some of them are highly detailed. So it's saying one state is a medical marijuana state really doesn't have a whole lot of meaning. So this report was intended to give context to what that is, and so we're going to take a look at the HB1 law and some of the features that it contains, as well as some of the features that are missing that some other states have included in their programs and have found helpful. And then I'm also going to go over briefly the APA guidelines, which are recommendations for manufacturing, cultivation, laboratory standards, etc. So this is what we'll be going over today. Americans for Safe Access. We are the largest medical marijuana patient advocacy organization in the country. We only focus on medical marijuana access and facilitating research. So our work is limited to just medical marijuana laws. We don't work on other types of marijuana legislation. We don't work on other types of medical legislation. Our focus is on medical cannabis, patient access, physicians' rights, and expanding research. We have 50,000 members. We have at least one member in every congressional district in the country, including Guam, which recently adopted a medical cannabis program. And we've been around since 2012. The organization was founded largely as a campaign with the 2002 petition to reschedule marijuana. That was about a 10-year process through the federal courts that was ultimately denied. But I think we'll talk a little bit later about prospects for federal rescheduling. So cannabis as a medicine, briefly as some of the herbal overview. The first evidence of medical cannabis use goes back about 5,000 years ago to China. It was used for everything from malaria to constipation to rheumatic pain, absent-mindedness, and quote-unquote female disorders. Another Chinese herbalist of around the same time used a mixture of hemp, resin, and wine as an analgesic during surgery. A little more recently, going back only a couple thousand years, in India, cannabis has been recommended to quicken the mind, lower fevers, induce sleep, cure dysentery, stimulate appetite, improve digestion, relieve headaches, and cure venereal disease. Africa, it was used historically for many of the same reasons. Cannabis was a part of the American herbal pharmacopoeia, part of the pharmacopoeia until 1942, and it's currently available by prescription in the Netherlands, in Canada, Spain, in Israel, and Eastern Europe is expanding access to. And the American Herbal Pharmacopoeia issued the monograph on cannabis in 2013. Modern pharma view on medical marijuana. In 1937, the U.S. passed its first federal laws against cannabis. And this was despite the objections at the time of the American Medical Association. The AMA said it knows of no evidence that marijuana is a dangerous drug and warned that prohibition loses sight of the fact that future investigation may show that there are substantial medical uses for cannabis. And we lost out on about 50 years of medical cannabis research as a result of that. So we're starting to catch up to that. In the mid-90s, the endocannabinoid system was discovered. This is how the body interacts with cannabis as a medicine. The endocannabinoid system regulates a great variety of how your body acts. It's neurotransmitter receptors, how your brain is able to heal itself using cannabis after traumatic brain injury. This is part of that. Appetite, I think many of us are well aware of how cannabis can help with appetite, particularly with folks with wasting syndrome as a result of cancer or HIV. Chronic pain, pain itself, the endocannabinoid system definitely works in how the body regulates that, and a variety of other issues that the body deals with. The endocannabinoid system is involved in much of that. To date, there have been more than 15,000 modern peer-reviewed scientific articles on the chemistry and pharmacology of cannabis and cannabinoids, as well as more than 2,000 articles on the body's natural endocannabinoids. There's supposed to be a database of studies here. I'm not sure if I'm going to be able to click onto it, but on our website, there's a link to this database of studies. There's more than 300 clinical studies. Granted, these are very small-scale studies. But they deal with cannabis in some form or cannabinoids, whether it's in the lab or small trial studies. So moving on to the current situation in the states. We now have 39 states, plus the District of Columbia and Guam, that have some sort of medical marijuana patient protections. 13 of these we call full medical marijuana states. Very briefly, these are states that don't put limitations on THC percentages or don't establish minimum floors for CBD. They allow the patients to use their medicine in whatever manner the patient is most comfortable with. They allow for a great variety of medical conditions. And so these are sort of like the general principles of what is a medical marijuana state as we define it. There are another 16 states that either have CBD protection laws or otherwise limited. Louisiana, who recently amended their law from back in the 80s that was inactive. They've done something similar. They've established a commission, but theirs is not a CBD-only approach or a CBD-focused approach, rather. It doesn't place limits on the amount of THC, but it's only available for 3 conditions and very, very limited circumstances under those conditions. And there's also the word prescription in there, which could be a problem in medical cannabis laws. Prescription has to be an FDA-approved substance. That's why you see written certification or written recommendation in state medical marijuana laws instead of prescription. But so we now have 39 states plus the D.C. And Guam that have these laws. That's over 275 million Americans, so 85% of the population now lives under some sort of medical cannabis protection. Approximately 2.4 million patients use these laws. These are just the patients who are registered to the program, so in states that haven't had a registry up and running yet, those patients aren't being taken into account for. And Washington State and California, they had volunteer registries. They're starting to do away with that. Washington just got rid of theirs. California is on the verge of doing that. So I imagine we'll see this number go up. But it's about 1 in 100 people in a medical cannabis state tend to be a patient. That's about the ballpark figure that holds across the board. So in some places it's up to 2%. Some places it's about 0.5% of the population. But generally about 1% of the population is a registered medical cannabis patient. States with these programs have seen drops in opioid overdoses and highway fatalities and have generally not experienced an increase in teen use. I realize some of these are counterintuitive. There was a recent SAMHSA study that came out that showed no association really between highway fatalities and marijuana use. However, when marijuana use is combined with alcohol, that is a pretty dangerous combination. That's even worse than drinking alone. But marijuana itself has been associated, the medical marijuana laws have been associated with somewhere between an 8 and 11% reduction in highway fatalities in a number of the states that have adopted these laws. Federally, it's an exciting time. I've been at Americans for Safe Access since 2011. And mostly been working at the state level. This past year, it's been a lot more at the federal level. There's more and more interest from our senators and representatives in Congress to do something affirmatively to advance research and allow for patient access. We've already had several votes this year in Congress on medical marijuana patient access. Sort of a tricky amendment, the Veterans Equal Access Amendment. It would allow physicians, VA physicians, to write recommendations for VA, for veterans who get their health services through the VA in states that have a medical marijuana law. This was a bit of a hard sell to some members of Congress because they thought this would be allowing federal employees to be facilitating the use of a Schedule I substance. So in the House, we lost by 3 votes, and actually that was more fluke than anything else. There were 2 votes no that should have voted yes. One was an accidental no. Representative Garamendi in California accidentally hit no and has made amends for that. And Rep. Griffith from Virginia, who has introduced a medical marijuana bill himself, said that the Veterans Access Amendment didn't go far enough, and that's why he voted against it. So it was a bit of a frustration there. So if those 2 votes had gone the other way, we would have seen 212 to 211. So really, really close there on that rather, difficult type of, not difficult, but it's sort of a complex issue. However, that amendment won overwhelmingly in the Senate, and I trimmed off. It wasn't quite 18-2. Our victory wasn't that great. It was 18-12. I trimmed off a 1 there. We had 4 of the Republican members of the Senate Appropriations Committee joining on that vote. The next vote we had was the Rohrabacher-Farr Amendment, which protects state medical marijuana programs from federal interference. This was an amendment to the Department of Justice's budget bill, and actually this amendment is currently in effect. It was saved by Senator Mikulski in the Cromnibus process that happened back in December when we almost experienced another government shutdown. But when they passed the budget, this medical marijuana protection amendment was in there. So right now, Georgia is not in the current one. Georgia will be in the 2015 version, which passed with 242 votes in the House. It was a very strong bipartisan victory, 67 Republicans joining 175 Democrats. In the Senate side, we did even better. We won 21-9 with 8 of the Republicans on the committee and 13 Democrats. 8 of the Republicans, that's half of the committee. Like Representative Garamendi, Senator Lindsey Graham, after the hearing, attempted to change his vote. He was confronted by a patient advocate outside his office, asked about the vote, which he had cast by proxy. He didn't realize that the vote went that way, and he tried to go back and recast his vote. He wasn't able to do that. So we actually have a majority of Republicans on the Senate Appropriations Committee who support the notion of not interfering with state medical marijuana programs.
Hey, Mike, before you go off that, and you may be about
Sure.
to do this, could you just explain the practical impact of that legislation on state laws like ours now?
Yeah, so what the amendment does is it prohibits the Department of Justice from spending any money from interfering with the implementation of state medical marijuana laws. There is a bit of a question as to what implement means, if that is just putting the law on the books and making the program accessible, or if that's all the activity that is carried out under the program. So there's a little bit of confusion as to if it protects both of these. In practice, it has resulted in that. We've seen the number of raids has almost completely vanished federally. There's still prosecutions of federal, state legal medical marijuana patients, but they are extraordinarily rare. Usually it's the providers who are federally prosecuted. This is almost universally true. I can only think of maybe 2 instances where patients were pursued by the federal government, but one of those was a pretty recent one in Washington State.
I just want to hit this point. For those citizens in Georgia who may have concerns that while they can legally possess cannabis oil once they've registered properly and have protection under state law, who have concerns that, well, I'm still worried that maybe some federal officer may come in, knock on my door and say, well, you're still violating federal law, therefore we're going to arrest you. This, for all practical purposes, eliminates that concern. Is that correct?
That is correct.
Okay.
That is correct, yes. And in fact, the only times when the federal government has gone after patients, it's when they've been cultivating their own medicine, which isn't even a feature of this program. So Georgia patients can rest assured that the federal government will not be interfering.
And the same would apply to physicians that are involved, I guess, in the process as well.
That is true, yes.
Okay. Yep. 20.
The most recent patient prosecution that you were referring to, was that where the patient was cultivating?
Yes, this was in Washington State. It was widely reported, the Kettle Falls 5 case. Washington State law allows patients to grow up to 15 plants per patient, and you could collectively grow 5 patients together, so they thought they could grow 75 plants. There's a technical clause in the law that says you can only grow up to 45 collectively. The federal prosecutor, or the local prosecutor, told the state police, chop down enough plants so they're under the 45 limit, and then the feds came in and prosecuted them after the fact.
Gotcha.
But ultimately, that prosecution resulted in not guilty verdicts on all but one charge. So patients have really been in a much better position lately. And again, the only time when the federal government has even shown any sort of desire to go after patients has been with cultivation. So there is a bill in Congress right now that would permanently fix the federal interference with state medical marijuana laws. It's the CARES Act. It was introduced in both the House and Senate as S-683 in the Senate by Senators Paul, Gillibrand, and Booker. It was introduced as H.R. 1538 in the House by Representatives Don Young from Alaska and Steve Cohen from Tennessee. This would make the Rohrabacher Amendment protections permanent and more binding. You wouldn't have that issue of what implementation means. The CARES Act would protect all state legal medical marijuana conduct from federal interference. It would also remove CBD extracts from the Controlled Substances Act, so the extracts themselves could be shipped freely across state lines. This would only be for extracts up to 0.3% THC, but it would remove that issue from federal shipping. And it would lift 3 of the major barriers to research. That's the scheduling in Schedule 1. The CARES Act would move to Schedule 2. The NIDA monopoly on the supply of research marijuana there's a tremendous problem with research in this country with medical marijuana in that there's only one source for it. And one of the studies that's been approved to do research on PTSD in Arizona, they asked for 4 different types of marijuana. After a year, NIDA was only, or the University of Mississippi, they have the contract through NIDA, was only able to produce 2 of the types of strains. A couple months later, they had 3, but they still didn't have the 4th. So, you know, this NIDA monopoly is a barrier to research. And then there's also the Public Health Service review process. This was established in 1998, actually as a means to facilitate research, but it's turned out to be a barrier because it's blocked a lot of research attempts from taking place, and has basically prevented people from even trying at this point. There's very few, other than Dr. Sue Sisley, who got the PTSD study approved, very few physicians or researchers are trying to go through the current federal channels just because they're so onerous. And just a reminder that all forms of marijuana are still considered Schedule I federally. This, for an in-state program, this hasn't been much of an issue when there has been solid regulations around the cultivation and manufacturing and dispensing of marijuana. The federal interference has typically happened in states that have had very weak state systems. So in California, where you didn't have a strong central oversight, or Washington State or Michigan, these are the states where we've seen the majority of federal interference. When you have a centrally run system from the state for this program, very, very little interference. In most states, no interference has happened. Colorado's had minimal interference. Arizona's had no interference. No medical marijuana state in the northeast of the U.S. has had any interference. So when you have a really strong regulatory system in place, the chances for federal interference, while they're technically still there, the federal government has been more and more moving in the direction of allowing states to move forward and respecting states' rights in the 10th Amendment. And the congressional votes have been backing this up. So moving on to
Mike, Mike, hang on before you move away from the federal. I think it should be noted that there are 2 pieces of legislation that you didn't chat about. If you'll just touch on briefly. S1333 and HR 1135, which I believe are called the Charlotte's Web Therapeutic Hemp Act. Is that correct?
Yes.
And if my understanding is correct, the purpose and intent of those legislation is to allow the transportation of low THC CBD oil across state lines without it being violating federal law. Is that correct?
That is correct. That is, the Rep. Perry has introduced that bill in the House. The Senate sponsor's name is escaping me, but it's similar to the CBD provision in the CARES Act. The one difference between that is the Perry bill would remove also the cultivation of low THC cannabis from the schedule, so it could be grown anywhere where a state allows it. You know, the state law would still allow it. So in a state, say Kansas right now, that doesn't have any sort of medical marijuana law or CBD law on the books, they would still need to have authorizing language. But here in Georgia, it would allow patients to receive medical marijuana CBD oils.
By FedEx, by shipping, whatever the case may be.
That's correct.
Yeah, which is a huge issue still and a challenge for it should be noted, too, that on the House version, there were 3 congressmen from Georgia who were co-sponsors of that. Austin Scott, who actually spoke about it, well, I guess they call it the well in Congress, David Scott and Rob Woodall, as well as Johnny Isaacson, sponsored the companion bill in the Senate. So I believe we've got some pretty strong support from our Georgia congressional delegation for a bill that would help directly what our bill has attempted to do here in Georgia. Is that not correct?
That is correct. One notable limitation, though, with the CARES Act, or with the Perry bill, and it's also the limitation within the CARES Act, is it only goes up to 0.3% THC. So I know that the state law here allows up to 5%. So it wouldn't allow the full range of what's allowed in Georgia to be shipped here. But for the Charlotte's Web type of products, these low THC products would be able to be shipped without any federal interference. That's correct. Okay, so I think I answered the question a little earlier. What is a medical marijuana state? Again, it allows for patient access, a robust set of qualifying conditions. Patients aren't to be arrested. They have in-state access to a variety of products, and they are not restricted in the form of how they wish to consume their medicine. The report has a state-by-state grading system, and in the 2014 report, we had these 4 categories of criteria, and we're adding a 5th. We're going to be doing an update to this report in this summer, and we'll be adding Georgia then to the report. But for the 2014 version, it was patient rights and civil protections, access to medicine, so access to cannabis or cannabinoid products, ease of navigation, the types of troubles that patients may face going through these programs, and functionality. It's great to have a program on the books, but are these programs actually working? Are the state administrations actually carrying out these programs in an effective manner? The report also, pardon me, contains model legislation, and like I said, the report will be updated in 2015. The thing that we're going to be doing different is we put product safety and quality standards. That was a component in the access to medicine category. We're going to pull that out and make it its own category, so they'll each be worth 20% instead of 25%. We thought product safety issues needed to be given greater emphasis, especially with the advancements that a lot of states are putting towards these. And the American Herbal Products Association will be grading that. That won't even be our grades. We'll be applying their grades to the formula. So in the patient rights and civil protections category, in some ways this can kind of be seen as the first phase of medical marijuana. We sort of at ASA like to talk about 3 phases of medical marijuana patient laws. The first phase is just establishing that legal right, that if you can receive medical benefit from marijuana, you have the right to get the recommendation from a physician, a right to possess and obtain and use the medicine legally, so that you won't go to jail just for using a substance that can help your health. Some states have a protection from arrest. Some do it in the form of an affirmative defense. Some combine these so that if you are operating just slightly outside the rigors of the law, say there was a 2-ounce possession limit in a state and you had 2.1 ounces, in some states you're automatically a criminal. That's a slam dunk conviction. In other states, the judge has discretion if you make an affirmative defense plea on those types of lines. Along with these protections from arrest are civil protections. These are very important. These cover child custody protections, employment, housing protections, and organ transplants are some of the big ones. These are really, really important. Just recently in Colorado, we saw that patients enrolled in the program can still be fired simply for being in the program. They don't have to have negative outcomes from their use at work. Just simply being a part of the medical cannabis program in Colorado is sufficient reason to be fired from your job. For child custody, we've seen in Michigan and in a couple of other states that when the parents are going through a divorce and one of the parents is a medical cannabis patient, this can be used against them in a child custody proceeding. So, if someone's medical cannabis conduct is actually leading to child endangerment, then absolutely that should be allowed. But otherwise, that's just a medication like any other, and a parent should not lose their custodial privileges and rights simply because they can receive benefit from medical cannabis. There are other ones. Organ transplants is a big one, and we are on the verge of a victory on that in California. About 9 states right now have organ transplant protections, so that if you're a medical cannabis patient, you won't get kicked off the organ transplant list. This is really, really important. There was a patient in California named Norman B. Smith who had cirrhosis of the liver and hepatitis C and was in a pretty severe stage of this. And he was on the transplant list. And he went through a conventional medicine program to help with his hepatitis. That at the end of 2 years, he was the only person still alive from this program. He was given about 6 months to live. He made it another 12 months, but he got kicked off the organ transplant list in California because they said the use, there may be presence of molds or fungus, and that could cause an adverse reaction to the transplant. There actually is scant evidence to back up this scare. And as a result, Norman, who was pretty tough, he didn't make it, and so failing to include these laws and these protections can have fatal consequences for patients. Reciprocity. This is obviously very important for Georgia patients to have this right in other states. When a state adds reciprocity, it's sort of a mission statement that the state is making on how it wants its patients treated when it leaves its state's borders. So reciprocity is sort of a good faith offering to allow other state patients to feel free that they can come to this state. Sometimes patients need to travel for visitation, sometimes for business, sometimes a parent gets transferred jobs, and a parent who is in Colorado gets a great job with Coca-Cola here in Georgia. I know that there's a provision here in this law that requires patients to wait a number of months before that they can enroll in the program. That can have some consequences for those types of individuals. So reciprocity is definitely important. State scheduling is less important, but it can be attached to the criminal penalties within a given state. So sometimes this is more important than others. Georgia does have good protection from arrest. Unfortunately, it does include some new felony crimes. So like I was talking about for patients who are over the limit, they don't have that flexibility here. In fact, they are, by definition, a felon if they are in possession of more medicine. This could be a bit of a tricky problem because patients have to fly out of state to get their medicine. And while the 20-ounce possession limit is good and should allow a pretty adequate supply, it does put patients in a bit of a difficult bind. How often can you get out to Colorado or Maine or someplace that will be able to provide this medicine to you and come back to your state? And are you going to be able, if you can't get back soon enough before that supply would run out, you're put in this position of do you violate the state law or do you have this supply of medicine on hand for the patient who needs it? I know the law doesn't contain civil discrimination protections. I believe the bill that was introduced last year by Rep. Peake did have some of these civil protections in there. If I'm not mistaken, I don't want to be imagining things here as I'm presenting, but those are definitely important components to maintain in a law. And the civil discrimination protections, we really like the Arizona model. It's right up on the screen right now. It's so that no school or landlord may refuse enrollment or leasing, except if they would lose federal benefit to do so. So and that's that's part of the employment as well. So these protections, they don't have to be absolute. Employers have to deal with the Drug-Free Workplace Act and those sorts of things. So these civil protections don't have to put anyone in an unnecessary bind. But you want to make sure that if a patient is going to lose a right or a privilege due to their medical cannabis use, it's because there was some negative conduct involved, not just the use of cannabis. So if someone's endangering their child by their medical cannabis use, sure, if there's actual danger there. If someone can't perform their job duties as a result, then that's something. But if they're showing up on time, being a good parent, they shouldn't lose their rights and responsibilities. Access to medicine. So how do patients acquire their medicine? Dispensaries and commercial producers, cultivators. These are that asterisk there is what is from our old product this score was derived by our product safety and those sorts of factors before. Personal cultivation and collective gardens, we're going to be somewhat lowering the point value on these next year because fewer and fewer states are adopting these and more states are getting their dispensary programs online. But the personal cultivation and collective garden access models are important in the meantime when a state is slow to adopt these central registries to get the programs up and running. So it allows patients to have access to the medicine right away. If you have a stage 4 cancer diagnosis, you can't wait 18 months for the state to get dispensaries up and running, for cultivators to grow the medicine, processors to process it in the right form. So, personal cultivation speeds that process up. And it also puts a little bit of motivation on the state to get its program up and running so that patients have that option to go to. It's much easier to regulate commercial providers than it is personal cultivation. So I know that there's a preference there. Explicit right to edibles, concentrates, and other forms. Some states only allow for right to the dried flowers of marijuana in their medical programs. Others only allow for access to oils and concentrates. Some allow for edibles, some don't. I know that there's some scares with children having access to candy or seeing these things, and they could be attractive to them. And that's certainly a problem in labeling and proper packaging that's tamper-proof, child-resistant is helpful with that. But edibles are also necessary for patients who have GI issues, Crohn's disease, issues that affect the stomach. Edibles are just about the most effective delivery mechanism that they can use in their medical cannabis therapy. We also favor programs that don't place limits or bans on THC or impose minimum CBD requirements. As far as CBD-focused states go, I think Georgia has the best of these limitations. 5% THC is a good amount of THC for a lot of patients. Many patients will need more. The 1-to-1 ratio threshold is also helpful. So, I think that it's a reasonable start. We obviously at Americans for Safe Access would advocate for removing these limits, but compared to where some CBD states are, where this is a much preferable situation for patients. So yes, registration ID cards now available. This is fantastic. I actually got chills down my spine when I heard that. I was so surprised. I'm from the District of Columbia. We passed our law in 2010. The first patients didn't get their cards until mid-2013. So, that was an extraordinary frustration, and to know that Georgia was able to do this in a matter of 4 months instead of 4 years, or not even 4 months, however long it was, this was really tremendous. However, the lack of in-state production or in-state access to products is definitely a problem. The fact that there is limited access to the Epidiolex studies is a good step in that direction to allow for some access. There are, I think, certain barriers to getting into these programs. For one thing, I think they're only available to pediatric patients, so adults who need access right away aren't going to have access to this. And Epidiolex has a lot of potential. I think it's a product that should be available to patients, and I definitely support its access availability. But it's essentially one strain of cannabis. And for patients who respond to that particular cannabinoid profile, it's wonderful. It's a wonderful product. But not every patient is going to respond to that particular cannabinoid profile. And in fact, when it comes to seizure disorders, sometimes it's not even CBD, high CBD concentrations that are helpful. There's a different cannabinoid called THCA, and that's how THC is found in the plant before it is combusted and converted into THC, so it's the precursor stage. And this cannabinoid has helped patients with seizure disorders. If you saw the Dateline NBC story this past week, Jennifer Collins was one of the pediatric patients, and she's been an all-star lobbyist in Virginia and now in D.C. She's going to take my job one day, I'm sure. But she uses THCA. CBD actually increased her seizures temporarily. And it's like any medication. Sometimes the medication works, sometimes it doesn't. There has to be a little bit of trial and error and adjustment, seeing what things, how a particular individual responds to a particular medication. And so for the patients that respond well to the Epidiolex product, that's great. But not every patient's going to respond well to this product. An additional difficulty right now for patients in Georgia is that they must go to another state that has reciprocity. We touched on this earlier. There are still the issues of federally bringing it out of state. When you step onto that airplane, there may be some issues. If you drive, say, from Colorado to Georgia, you'll be going through several states that don't have these laws to protect patients. And even if the state does have a law, it may not protect Georgia patients if it doesn't have reciprocity. So patients and their caregivers are putting themselves at risk every time they go and obtain the medicine. It's, I think just about any patient or parent, if they had the choice between having access to medicine this way or no access at all, would certainly take this. And it's a great start. It's better than no access, but there's difficulties here, and I think that's one of the great things about this commission is it seems to be focused on looking at ways to bring in-state access in the right way and in an intelligent way. Like I mentioned before, the 5% cap on THC and the 1-to-1 ratio. These are not items that we look for in our model legislation, but as far as THC caps and CBD ratios go, this is the best in the country. Access to medicine. Again, this is the consumer safety and provider requirements. This is that breakout that we had for our dispensary points. So we're going to be giving a lot more weight to this in our 2015 report. Mandatory lab testing and labeling requirements. Patients need to have good access to information for the products they're getting. One of the disappointing things in the DC program, I'll keep using DC as an example because that's where I'm from, but there's no lab testing. So we have labeling, and there is a device that can give some sort of a cannabinoid profile without intensive lab testing. But it's not particularly accurate. So patients in DC are not getting the best information about the products that are being made available to them. Patients are getting relief, and they're still able to use these products. And again, sort of that trial and error process, finding which strains work for them, which ones don't. But good lab testing and labeling are definitely helpful for patients. Also training, mandatory training requirements for dispensary and cultivation staff are very important. Some states don't. This is more or less a requirement across the board, but some states only require the operators to put their training plan into their application to become a dispensary operator or cultivation facility. The training requirements should be in the regulations themselves. They should be not onerous, but they should be focused on giving good information to the facility workers so that they know how to deal with cannabis and all of its applications for what they're doing with it, whether it's in a lab, whether it's growing it, whether it's selling it, whether it's interacting with patients. All that can be best served through training. Product safety protocols. This includes recall mechanisms. Again, in DC, you can't return your medicine to the dispensary, so it's impossible to have a recall. It's legally impossible in DC to have a recall. So that's something. If you're looking to include these features in a program, you want to at least be able to allow recalls. Ownership and employment restrictions. These tend to be for owners who may have a past criminal conviction based on marijuana. This is a bit of a double-edged sword. I know, we only want people to play by the rules in our programs, but at the same time, medical marijuana, while the laws are determining that it's medicine now, the human body determined it was medicine much long ago. So there are people providing this medicine outside the law previously who have expertise in this. And when we have these sort of restrictions, we can be losing that expertise. So again, we don't put too high of a point value on that, but it is something that can be harmful to patients in the overall program. Yes.
I'm gonna ask you. We're at about 2:30, so let's keep moving because I know we got a bunch of questions. So I understand the rationale behind the points system, and that's good. And we can kind of breeze through that, and because I know we probably have a lot of questions for you too. So
So ease of navigation. This deals with qualifying conditions, access to minors, the ability to add new conditions to a program, the ability to have caregivers. Is there a patient-focused task force or advisory board like the one we have here? Allowing reasonable fees for patients. You don't want to make the fees so high that patients can't have access to these programs. One of the reasons for this is there's no insurance coverage for medical marijuana. So patients have to pay completely out of pocket for this therapy. Right now in Georgia, they have to travel out of state, so that's an extra expense. And typically, people who are suffering from severe medical conditions are already economically challenged. So you want to make sure that the fees are not restrictive. Allowing multiple year registrations is helpful with that as well. Not putting too many burdens on physicians or requiring additional training. We think that it's great to have extra training, and we are actually working with Harvard Medical, with the Massachusetts Medical Society, to produce CMEs. And we think that there should be more and more medical education. But making it a requirement before a physician can recommend medical cannabis is not a good trait of a program. Georgia, the medical conditions here are better than most CBD-focused states, but it's still limited, and there's no process right now for adding new conditions. There are reasonable requirements to allow pediatric patient access. The advisory board is focused on improving the state program. The reporting requirements may be onerous, but I think they actually aren't upon a second thought. Just some thought on the ideal language for defining a qualifying medical condition. We believe it is any condition for which treatment with medical marijuana would be beneficial as determined by a patient's physician. This is akin to how a physician can recommend or write a prescription for any pharmaceutical substance for any condition. They can write prescriptions off-label. And as long as the physician is feeling in their medical opinion that this is beneficial to the patient, outweighs the risks, they have that right, and we think that medical cannabis deserves the same. Functionality.
Hey, Mike, before you go off that, that's been obviously a very hot topic in our state.
Sure.
Or at least I've gotten a lot of feedback of, okay, the 8 conditions, how do you determine them, why in this on there, why in this on there? Are you saying in most other states they either have a physician panel that makes recommendations for adding conditions to the list? Is that the ideal
Most
scenario?
states have some sort of either it's a board of physicians or it's part of the Department of Health. They have some sort of mechanism for administratively adding new conditions. That's correct.
Not through a legislative process, but more through an administrative process.
Right, that's correct. And that's in the majority of states. There's only 3 states that have this ideal language, and I think there's only 2 states that require the recommendations of the commission have to go through the legislature. I believe Minnesota is maybe the one state like that, and I think there might be one other. Okay. Functionality, again, it's great to have a law on the books, but if it's not serving the patients, it's just symbolic. So that's what this category deals with. I can breeze through this fairly quickly. Again, we've talked about these sorts of things that patients must travel out of state or enroll in one of the GW programs. The administrative work in the state is occurring in a timely fashion, and that is definitely commendable. The possession limits, again, workable, but the lack of in-state access could be problematic. So moving on to the APA guidelines. APA is the American Herbal Products Association. They set the best practices and standards for herbal products and supplements, and were responsible for passing federal legislation back in the 1990s to facilitate that. APA recommendations for regulators cover 4 areas: dispensing operations, laboratories, cultivation, and then manufacturing, packaging, labeling, and holding operations. And for enabling legislation, it's fairly simple. This is from our model legislation. If the state adopts a provision that says the department will adopt product safety standards for cultivation, manufacturing, et cetera, from the APA guidelines, they don't have to use the APA guidelines verbatim based on this language, but to use that as a basis for the implementation of these regulations. This is also a little bit more of a detailed follow-up provision that would be helpful in initiating these. I hit that one twice, apparently. So these are the sets of regulations that are in the dispensing operations portion. As you can see, it covers full gamut of what you would expect to see in a well-regulated system, from requirements to be able to make the purchase, adverse event records, so again, how you can do recalls, rights and responsibilities of compliant individuals. All these sorts of things are covered in these regulations for dispensing operators.
Okay, so I want to make sure. So what this last part that we don't see the body of is basically your model legislation?
No, that is in the PFC guide that it's in the stack of materials I gave you. The full set of regulations are in there, and I can also provide links. They're on APA's website as well. Okay. The APA guidelines were developed by their cannabis committee, which has a number of physicians and medical cannabis experts on it. So that's where these regulations are derived from. Again, the laboratory operations, it covers just about everything to dealing with labs. There's no way to go into tremendous detail here, but the regulations packet has a lot of that information in it. These are intended to establish a basis for the oversight of entities performing laboratory analysis of cannabis, cannabis-derived products, and hemp products. These guidelines were developed as a complement to existing good laboratory practice and focus on the personal security, sample handling and disposal, data management, personnel safety and hygiene, and reporting activities that may be unique to labs. So it runs the full gamut. Cultivation operations, again, these are intended to provide a basis of oversight for entities that cultivate cannabis in either outdoor, green door, and/or indoor facilities. That is probably going to be one of the bigger issues that you face when determining what type of cultivation model you should you choose a cultivation model. That'll be an issue. It's much more efficient and environmentally sound to use greenhouses. For security and regulating purposes. I understand why indoor cultivation in a warehouse type of facility may be appealing, but it's definitely more resource intensive to do so. An outdoor cultivation in rural areas is something that can be also achieved. But again, I think greenhouses are the best compromise for this, and allowing the products to be sun grown. And the manufacturing, packaging, labeling, and holding operations, these are definitely the most intensive part of the regulations. And they are designed to provide a basis for oversight of entities that are engaged in manufacturing cannabis and cannabis-derived products. These guidelines are modeled after the federally recognized good manufacturing practices, so GMPs, for botanical and nutraceutical products. And these recommendations ensure that GMPs are maintained in the manufacturing operations by focusing on personnel, the physical condition of the plant and the surrounding grounds, manufacturing controls, packaging, holding and labeling controls, cannabis material acquisition, inventory and record-keeping, complaints, returns, product safety recalls, and adverse event recording. So, again, the full gamut. The details of those regulations can be found in your packet.
And we're expecting every commission member to have that read and fully understood by the next commission meeting, just in case.
And open up to Q&A.
All right. Well, I hope, commission members, that you got a lot of questions for Mike, because I think he's, like I said, foremost expert of what's going on. Let me ask one to get us started, and based on what you know about Georgia and what we've passed, very limited CBD bill, but a little further than what other CBD states across the state. And knowing also the governor of the state has said we are not going down a path of legalization of marijuana for recreational purposes, and I believe that's strongly that's the will of the General Assembly as well too. But we also know we have an access problem. Based on that knowledge of where we are as a state and where the posture is, do you have a state out there that we would look to and go, hey, here is a model for where you want to go if you want to provide access for medical cannabis oil that is in existence right now, and also what is the one we ought to avoid? What model state? So can you answer that briefly?
Sure. I think the second part of the question is a little easier to answer. New Jersey's law is clearly the one to avoid. They've been up and running since 2000. They've been up since 2010. Running is far too much credit. They've had 2 dispensaries open. There have been access problems throughout the entire state. There's limited conditions. Patients are fleeing the state to go elsewhere. It is definitely one of the models to avoid. In terms of models to look at, our favorite program in the country is Maine. I'm not sure if Maine is a program that politically would be feasible here because of the personal cultivation rights that exist in Maine. So with that in mind, I think 2 models that Georgia should really be looking at are the Arizona program, which is a comprehensive program, very strong state regulations. There is limited personal cultivation rights, and that's for patients who live more than 25 miles from a dispensary. They can have that right, but they have to register additionally with the state to get that right, and I believe they may be open to additional inspection as a result of that. But Arizona has a very comprehensive and well-run program, and I think it's one that politically might be feasible here. Also, Maryland. Maryland had a very similar political evolution as Georgia has on this. In 2011 and 2012, then Governor Martin O'Malley said, no way, never signing a medical marijuana program, not going to happen. 2013, state said, well, we'll take a look at this and we'll try to come up with a academic medical center focused program try to make it look as much like an IND program, investigation new drug program, as much as possible. That didn't work. 2014, Maryland passed a much more robust program and allowed the commission in Maryland to establish regulations. Maryland adopted many of their regulations from the APA guidelines, not universally, but they took a lot of that knowledge and applied it. And Maryland has a really great framework for a program. Now, Maryland's isn't up and running yet, so we don't know exactly how it's going to work in practice. But between Maryland and Arizona, I think that there's a lot that Georgia could learn and would be politically viable.
Okay. We got a couple questions. Dr. Retterbush.
Just to follow up with Representative Peaks said, my question is, how many medical marijuana states have only a state-regulated commercial production of CBD oil as the only source for a patient to get that?
Right now, the only state that has a comprehensive in-state production for CBD oil products is Florida. Unfortunately, the implementation of the Florida program has been a mess. A lot of that has to do with the law that requires the growers have to be in business for 30 years. They have to have the capability of producing 400,000 plants. Yeah. So Florida.
Somebody's daddy was related to a Florida state legislator, obviously.
Seems to be the case. So far there really isn't a good model to point to for CBD focused production. I know that both South Carolina and Missouri, their laws are a little more open to interpretation, and I believe there is some in-state production going on right now in South Carolina, but it is not regulated by the state in the type of way that a normal medical marijuana state regulates in-state production.
Quick follow-up question. How long does it take to get commercial production up and running?
It takes probably 18 months or so to get this done if it's done right, because you have to have a merit-based application process. You want to make sure that you have good actors coming in there. Once you've licensed these parties, it's going to take them some time to build out their facilities, and then it's going to take anywhere between 2 and 5 months for the first crops to become available. Generally, the first crop that a cultivation facility comes across is significantly weaker than subsequent crops because they have to figure out which of the plants are going to be their clones for reproducing these plants, and so there's a bit of a learning curve of sorts there. So it takes about 18 months in the best case scenario to get these products available for patients. So taking the speed of bureaucracy into account to some extent, but as we've seen here in Georgia, you all are going faster than that. So maybe you all can do better.
Okay, thank you.
As long as Dr. Fitzgerald's involved, we're going to be moving pretty darn quick, I think. So. Dr. Whitmore.
I just had a question. My understanding was that in Minnesota, they had 2 growers that were designated as physicians working with local agricultural groups. They're growing it inside. Those 2 growers were provided then to 4 dispensaries, and they selected the growers in December. The dispensaries started the growers started growing, and they're supposed to be dispensing in July.
Mm-hmm. Yeah, and in Minnesota, this may be moving faster than in a lot of other states. The one thing I will say with that model is with only having 2 growers, if either of those facilities has a problem, you're talking about a 50% reduction in the availability of access to medicine in state. So, Minnesota has done a good job in getting that up and running, but this is 18 months is typically what we've seen in most states.
I think one of the positives in Minnesota, they've partnered with 3 generations of agricultural people that are the Bachman's floral family, and so they have. I mean, I don't know about Pikes, but they're a family that's been in floral business and growing for a long time. So they have all the indoor greenhouses and already set up. So that may help.
That helps, and also having a Department of Ag involved with that. When it's been just left to the Department of Health to deal with cultivation of botanical medicine. That's not something that they have the institutional knowledge to handle all that regulatory work. So Department of Ag is definitely helpful when it comes to cultivation regulations.
I would imagine if it's any indication by the number of farmers that have contacted me in the last couple of months, we're going to have our Department of Ag deeply involved. Dr. Sutton, hope you're prepared for that.
Better weather here.
I want to piggyback off that question while I'm not showing any more questions. If you got a question, hit your button and we'll get to you. Based on the fact that you've said Arizona is a good model and Minnesota obviously is doing something right, would you recommend a scenario where there is a number of licensed providers? That's the first question. And then would it be licenses granted to cultivate, process, and distribute, or do you break up that second piece of part into different licensees as well too? What's the best recommendation, the best model?
I think a good way of moving forward is to set some reasonable limits on the number of licenses that will be issued in the first year or 2, but allowing the regulatory body to increase that number should that number proved to be insufficient to meet patient demand, or if the cost of medicine is too expensive, or if there's other reasons why there should be more cultivation. So you can set limits, but give the department some flexibility so that their hands aren't tied down the road with this. And what was this?
And the dispensaries would be allotted on a merit-based system rather than a lottery system, which they're doing in Florida or something. I mean, that's the recommendation.
Right, and actually the lottery system is probably the one flaw with the Arizona program, that they did it that way. It turned out that they had pretty good actors involved, but not across the board. And through a subsequent round of regulations or applications, they've gotten better actors into the program. Okay. In terms of breaking up the licenses, there is some value in that, but I think sort of a better way of looking at it is to not require vertical integration, but to not forbid it either. There's going to be some businesses that from other states that have done a really good job in both growing and dispensing cannabis products that would probably like to do business in Georgia and could provide a valuable service to patients here. Some businesses want to focus more on the production of medicine and maybe better at that. Some will want to focus on the dispensing of it. So I think allowing the flexibility of having dual licenses for that, but not requiring vertical integration is the ideal way to go.
Let me take a step further. Would you say that it would be a detriment to require vertical integration? That one vendor does all three parts? Would that, if you said that's the only way you can do it, that would not be the best? Is that what you're saying?
Right, and the problem with that is the variety of products becomes more limited. Each dispensary then has a set of products, and so if you're in one part of the state, your dispensary there, they were only growing their types of cannabis. They only produce their products. They're not able to get these products from other dispensaries. So if you live in an area that their dispensary focused just on CBD products and you needed a higher THC product, you might not be able to get it there, or vice versa. Okay. Actually, and more often than not, it's the opposite the case.
Okay, and we'll take one step further. Have you seen any states where the state government has been in control of the entire process, where the state government grows it, processes it, and distributes it without private enterprise being involved?
No, we haven't seen state cultivation and distribution.
Okay. Okay, members of the commission, any question while we got him? Here's your chance. Law enforcement, you guys got, I know y'all got a lot of questions about this coming down our path. Let's see. Yes, Ms. Reese.
Okay, sorry, I have a question. What role does the pharmacist play in Maryland and Arizona? I know that they are involved in Minnesota and Connecticut. I know Connecticut dispensing, Minnesota more the counseling, but is there a role of pharmacists in Arizona or Maryland?
In Maryland, there definitely is. I can't say with certainty that there is in Arizona. I believe that pharmacists are allowed to be part of the dispensing operations there. Maryland was going to make it a requirement to have a pharmacist as part of the the distribution staff, and pharmacists definitely play a great role in that because a lot of the knowledge that patients get from how to use their products. How certain products have certain advantages. Pharmacists are probably better suited than regular individuals to do this. But again, training of dispensary staff can give them a sufficient level of expertise. But I think pharmacists definitely have a role to play, and requirements that pharmacists be involved with an organization wouldn't be too onerous and would probably be helpful.
Okay. All right. Thank you.
And that would be your recommendation?
Yes.
Okay. Mr. Rickman?
You may have just answered my question. It's kind of a big one, but it dovetails exactly on when it seems that everything that we've been discussing, we talk about the sort of infrastructure we already have, pharmacies, doctors, physicians, and then dispensaries as being separate. Mm-hmm. And you may have answered the question, that is, it sounds like, would you be saying that if the federal barriers were removed, that both the CBD oil and any other medical cannabis, if it passed through the normal channels, through pharmacies, can you just elaborate on that, how you would feel about that, or what?
To some extent, we're going to have to cross that bridge once we get there, and that I think is probably more for states that already have existing programs, because a state that has a robust dispensary system, are you going to turn those dispensaries into pharmacies? Do pharmacies turn into dispensaries? How do you determine that? For states that will be coming online after those federal changes, which may or may not happen, but if they were to happen, I would expect them to follow more of a traditional pharmacy approach, just because the infrastructure is already there, and that would probably be the most rapid way of getting it to patients.
Ms. Reese, I may ask you to, if you don't mind addressing that. I mean, is there any opinion from the Pharmacy Association on this issue?
Sure. I am a member of the Georgia Pharmacy Association, just for clarification, and I was on a phone call last night and with some folks with the association. Currently, since it is a Scheduled I controlled drug, the distribution of the product, pharmacists could not do legally. Now, with that being said, pharmacists could be involved in counseling and discussing with patients the product and understanding how to use the oil. Can it interact with other medications that our patients on? Because we all know herbal products, natural products, can interact with medications. So pharmacists could have a role, not necessarily the way federal legislation currently stands, they could not, but down the road they could in dispensing. But right now there could be an educational role. And a couple of options I was looking here, just kind of doing some homework on what other states have done, is if the federal barrier is removed, is for the dispensaries that are already in place, have them say you need to employ a pharmacist, would be one option, and make them get some type of license like we do other pharmacies, because it would be some medicinal product, would be a medication, and then also allow pharmacies to start doing it. So there could be sort of a hybrid and mix of what lots of options there. But I would like to see the association, different pharmacists have different opinions. I'm not saying all pharmacists feel this way. Even within the association, there's varying opinions, but even in the current situation we're in, pharmacists could be involved in counseling, educating patients on the particular medication. And being a faculty member in a college of pharmacy, we train our students. Joking, people joke, they say pharmacists count by fives. We really don't train them to do that in school. But we do train them to, and we have classes on dietary supplements, herbal medication, so that they are equipped to do this type of education. So.
I hope you would, Ms. Reese, continue to engage the association. We want their input on this issue, and it'd be nice to come up with a recommendation that they could give to us, to the commission. If you'll push them a little bit on that, that'd be great. That'd be good. So, yep, Dr. Wimmer.
As part of my medical practice, I have also counseled patients on interactions with natural substances, St. John's wort, even vitamin B. Vitamin B interferes with some chemotherapy agents, and we recommend the children not to be on that when they're taking the chemotherapy. I think our pharmacists are very skilled at working with patients, so I don't see that would be prohibited by the current bill, to consult with pharmacists for advising our patients what are metabolized by the same mechanism, and so as not to harm the liver or other organs.
Dr. Park.
But in order to provide our patients through the professional MD and pharmacist, we got to have a scientific evidence, what the drug-drug interactions, what the side effect, but we don't have those data yet. That's the biggest, very concerning. So this is a patient's own risk. If it's something dispensary to saying is high CBD, low THC, but how do you believe that's the correct one? How much pesticide in it or not? So once is we don't know is a long-term effect to the brain development, particular THC for growing children. Though, if it's something happen for down the road, is 10 years, 5 years, even shorter durations. If something happen, who is going to defend the physician who happen to be provide advice? So who is going to? Is legal is very troublesome in here. So I don't know whether it's the right directions or this is not the conventional drug development process right now. This is a more awkward way to do so. We have to more discuss detailed in order to provide our folks to take in this one. So.
Yes, those are definitely reasonable concerns to have. Cannabis has been around for thousands of years as a therapeutic substance and generally has been fairly benign, certainly compared to some powerful narcotics and opioids that are available and out there. In terms of protecting physicians, as long as a physician is using their sound medical judgment and truly is thinking in their professional medical opinion that the use of this substance, based on the knowledge that we have on it today, will provide benefit that exceeds the potential risks that we know today, physicians, I believe, would be insulated from any sort of retribution or punishment in the future should we learn something negative down the road. We certainly could learn something negative down the road. However, most of the research that comes up seems to be pointing more and more in that direction, that the cannabis has therapeutic applications for conditions that exceeded what we initially thought. Most people initially thought just cancer, just glaucoma, just these sorts of things. Now we're finding out with digestive issues such as Crohn's and IBS, with the seizure disorders, traumatic brain injury, post-traumatic stress disorder, phantom limb syndrome, ones that affect veterans. That the potential benefits, especially when there isn't a pharmaceutical product out there right now that is providing benefit. Again, in the case of PTSD, many of the veterans aren't getting relief from the pharmaceutical products that are available for that, but they are getting relief from cannabis. And right now they're self-medicating, and they're doing this on their own when there isn't a medical cannabis access law. So it's good policy to get these people into the system who are self-medicating right now, have them go to a doctor, have them get as much oversight and supervision of their use of this substance as possible, rather than doing it in a clandestine manner.
Dr. Park, I hope the waiver we've established, at least in this process, I hope will protect physicians. That was the whole intent. In fact, it was put forth by a senator in the chamber, Senate chamber, who was a physician and was a key important. But that's a valid point. We look forward to working with Medical Association of Georgia to kind of hopefully address some of those issues as well. Any other questions? Yeah, Dr. Sutton. Sorry.
How's that? All right.
Okay.
Those states that do allow in-state production, is there a limit as to that production? And if so, is it the number of plants or the amount of material that's produced?
There are a number of states that do have cultivation plant limits. Again, District of Columbia is an example. Had a 95 plant limit per cultivation site for a while, and this was really, really ineffective. We were growing very small amounts of medicine. Medicine shortages were common. They still are common, but they're less common now. They've increased the plant limit now, I believe, to 1,000. Generally speaking, businesses will only produce enough medicine that is sound and feasible for their business model. But if there's going to be limitations on the amount of plants that are being grown, best practices are to do it by the square footage of a facility rather than the number of plants. If you do it based on the number of plants, then people are just going to be trying to grow the biggest plants that they possibly can.
Sure.
And you get these Christmas trees of marijuana. But when it's done by square footage, it's more easy to control, and it's also easier to regulate that way.
Director Keenan, did you have a question?
I did. When talking about patients and doctors prescribing medicine, i.e. certain forms of marijuana, what do you see the role of local and state law enforcement in this equation, or is there a role?
This is definitely a tough question for law enforcement, who traditionally have been charged with the task of making sure that marijuana is not out there in any form. So this does put law enforcement in a bit of a tricky situation in terms of making a determination. Is a patient, is someone in fact a patient? Is someone possessing more than they need? So having clear guidance from the state as to what's legal and what's not legal, and having a good registry system so that law enforcement, if they come across someone who is possessing medicine, that they can verify what their credentials are, and this will allow law enforcement to handle that dual task of illicit marijuana enforcement, but also allowing patient access. And so that's where law enforcement fits into the equation.
It is going to be crucial, Director Keenan, and to our sheriff and police chief, to have the involvement of the Sheriff Association, which we had significantly over the last year, and the Police Chiefs Association involved in this, to make sure we get to a point that law enforcement is comfortable. We have the guidelines set up in a proper manner. So, again, just like I implored Ms. Reese to the Pharmacy Association, we're going to implore your groups to be actively involved again during this process. So, did you have, Sheriff?
I was going to say, on the sheriff's side of it, I think that a lot of the things was answered when we met with you down in South Georgia. We met below Macon. A lot of people was wondering the same thing with these doctors. Every county in the state has we call them pill mills. If you'll show up and pay your entry fee to get in the door, they'll write you whatever prescriptions you want. The sheriffs all over the state had an issue with this going on. And when we met with Representative Pete, when the THC level fell 5%, it took all the, for lack of a better word for it, being high and driving on our roads out of the equation. Mm-hmm. So the sheriffs of the state is probably our biggest concern is that meeting these people on the roads driving. As far as with the children that's having seizure disorders, I don't think a sheriff nowhere in the state had any issue at all with the doctors seeing, treating, and prescribing them with this medication. I agree with this doctor. There's probably not enough research out here for us to make an educated decision. So this board is, for lack of a better word, we've got some new ground to plow.
Mm-hmm. We do. Yeah. Thanks, Sheriff. Okay. Any other questions? Yeah. Ms. Reese. Oh, there we go. Gotcha.
Okay, sorry. On the federal level, is there any type of legislative work being done with the CBD abstract? I know there's several legislation pieces, but like any waiver for liability for physicians or whatnot that are using these products, like we've seen with vaccines. Now, granted, you're looking at different research. It's FDA approval for vaccines, but it's very difficult with this type of medicinal product to have that type of research. I know research is going on, but any work towards some type of waiver protection for providers?
Yeah, and it's actually one of the reasons why Senators Gillibrand and Booker and Paul introduced the CARES Act. Senator Gillibrand, along with her fellow senator from New York, Senator Schumer, they sent a letter to the Department of Justice asking just for a waiver, just as you described, to exempt the New York State from federal laws regarding the importation of cannabis oil or CBD oil. The request for waiver fell on deaf ears, and that was part of the inspiration for those senators to introduce the CARES Act.
But also from the aspect of the patient, like a parent getting upset and deciding to sue a provider because their child had an adverse effect from the CBD extract. Any work on a federal level related to that?
In terms of waivers for providers?
Yeah.
No, I don't believe there's any work on that right now. So,
right.
Sorry.
Sheriff, we got your button. You got
one more question for you.
Sure.
I've had a lot of questions and calls from sheriffs around the state and also from the citizens in the county where I'm at. Do you have any kind of idea in your mind if they put this under like the University of Georgia or some university system that would grow and cultivate it and do it all to keep it away from, I guess, to keep it all under one umbrella where it could be controlled better? I know the sheriffs of the state have got it. They're going to have some issues with if one of these dispensaries are in their county or one of these grow operations are in their county, being able to control it and keep it safe for their communities. Because, you know, in order to do this, like I said, if you don't go in a greenhouse, if you're going to have to go outside, you're going to have to go to some of these agricultural counties, and most of these sheriff's offices are stretched more than thin. Montgomery County lost their sheriff this morning. He has 7 deputies. You know, if they put it in the middle of Montgomery County, they don't have anybody to go check on it, to monitor it, and most of the people that I've talked to thinks it would work to go like under a university system. And I was going to see if you had any comments or any dealings with some university system that's growing it. I know there's ABAC. There's all kind of universities that they specialize in growing stuff. I was going to see if you had any dealings with that at all.
Yeah, and in Maryland, that was what the 2013 law was originally designed. It would actually have been private contracted growers growing for academic medical centers, which are essentially teaching hospitals that do human subject trials. So it was all going to be, but all the dispensing was going to be done through the hospitals, and it was going to be very centrally done through these hospital locations. None of these institutions wanted to get involved because the federal accreditation issues that are at play with dispensing a Schedule I substance. So it was sort of a dead law from the moment it was passed. And that's why Maryland went with a more robust and comprehensive approach. To answer that question about the ability to enforce adequately around cultivation facilities in rural areas, that could be a consideration that the Commission takes into account, or the Department takes into account when vetting applications for cultivation sites. The cultivation site location would be a part of the application packet, and whether or not it's in an area that could be adequately patrolled could be a component for how the licenses are awarded. So that could be taken into account that way.
Sheriff, I know in the original legislation we had 2 years ago, the thought was to go the academic route, and it was a flawed process because no universities wanted to participate and risk losing federal funding. So that was good. It was a good thought, but in practice just didn't work. So. Well, you're right. You're right. Why don't you got sway with your congressmen and senators here? I begin to wonder.
I'll deliver any messages to Washington. I'm happy to do so.
You can deliver this message. I've said it publicly. Just change the damn law. So, and then it'll make it a whole lot easier for us. My mother would be mad at me for cussing in public. So, but in the same breath, pat me on the back and saying, "Way to go, son." All right. Any other questions for members of the commission? For Mike. Mike, thank you for traveling from Washington. We appreciate the input and expertise. This has been very helpful for this commission. We're grateful for it. So thank you.
Thank you for the opportunity to speak before the commission. And like I said at the beginning of this presentation, I hope that this is an ongoing conversation. You can reach me through the contact information on the packets. Happy to answer any additional questions you may think of later.
We're going to continue to use you. Thank you. Appreciate that. Members of the commission, you should have hard copies of both the presentation from Dr. Fitzgerald and from Mike, and we will send those to you by email as well too. So, and I think all of you, everybody's getting the messages we've been sending out. Communication, is that right? Okay, everybody's good. We will attempt to give you about a month notice, if we can, for our next meeting. And again, probably we'll wait till after the summer holidays are over. So probably late August, early September. It'll be a middle of the week, probably like this, afternoon time. I know it's difficult to arrange for a situation where everyone can be here. Those of you who have appointed positions, feel free to send a designee like Dr. Sutton today. That's as long as we get input from the state agency. I think it's crucial. Any other comments from the commissioner? Any other questions as we move forward? Those who are not members of a state agency will be receiving a per diem for this, so I'll be in contact with you to get transportation distances as well too, or reimburse you for your mileage to the meeting today. And again, let me thank you. I appreciate it. It's a good start. We got a difficult task ahead of us, but a very important one that means a lot to a lot of people in our state. It's crucial that we come up with the right solution. Governor Deal has challenged us to do that. And so I look forward to working with all of you to come up with that right solution. So we are adjourned. Thank you.